Hello, y'all having a good time back there, huh? Did y'all solve all the problems of the day? Good. Good afternoon. Thank you so much for coming out to this hearing today, to the Public Health and Human Services Committee hearing Resolution 140025, which is the Pennsylvania Conservatorship Act issue we will be discussing. Let me have the clerk read the resolution.
Resolution 140025, authorizing the Council Committee on Public Health and Human Services to hold hearings regarding the Abandoned and Blighted Property Conservatorship Act of Pennsylvania.
Thank you. Let me recognize that we have with us this afternoon Councilwoman Maria Quiones Sanchez. As you know, she's been moving the land bank program, and certainly this can fit right into that. And our majority, whatever, with Councilman Greenlee. And and other council members will probably join us as we go through the discussion. So I want to say good afternoon to all of the panelists who are here and guests, and I'd like to thank you for being here to testify regarding Act 135, or the Pennsylvania Abandoned and Blighted Property Conservatorship Law. Your input is vital as we begin a conversation during this period of the city budget hearings to discuss how we can better utilize this economic redevelopment tool. During the hearing, our goal is to discuss the history and background of this act, case studies on how various organizations have used this tool, the public sector response to the conservatorship law, and creative and future uses for conservatorships. Although we will discuss these topics, for me, today is also a discussion regarding Artie's. For those of you who may be too young to remember Artie's, Artie's was a retail clothing store in the city. And in the 9th Councilmatic District, an Artie's store was located at the corner of Ogons Avenue and Washington Lane. Although Artie's closed many, many years ago, and I've been here maybe in public office 30 years, and it was closed then, the owner held on to the property and literally did nothing with it. Well, he did do something. He paid the property taxes, and that's it. In 1983, Dwight Evans created the Ogons Avenue Revitalization Corporation, or ORC, and began to develop the community. However, the old Artie's property remained abandoned and blighted. As the business corridor improved, several attempts were made to purchase the property. Yet the owner would only accept an offer of tens of thousands of dollars above any reasonable appraisal. As Ogons Avenue grew and sprouted with redevelopment, a tree grew and sprouted in the old Artie's building. Finally, and due to the leadership of Representative Taylor, Governor Rendell, and other stakeholders, Act 135 was signed into law in 2008. In a short period of time, the old Artie's property was redeveloped into a Tang pharmacy and a medical office. In my opinion, if it were not for the conservatorship law, the old Artie's property would still be an abandoned and blighted property on Ogons Avenue. Through today's hearing, I hope that we will be able to discuss other examples and begin a conservative conversation on how to improve and better utilize the Pennsylvania conservatorship law as a redevelopment tool for our communities and our city. So I'm excited to hear what you have to say, your experiences in dealing with this law, and again, thank you all for coming. So our first panel will be Cindy Whitman Daly, Policy Director of the Housing Alliance of Pennsylvania, Judy Berkman, Esquire, Managing Attorney, Regional Housing Legal Services, and Beth McConnell, Policy Director, Philadelphia Association of CDCs. Good afternoon.
Afternoon. So I coordinated with my colleagues here on our testimony, so I'm going to start us off, if that's all right.
That's fine. Thank you.
Well, good afternoon, and thank you, of course, for the opportunity to testify about Pennsylvania Act 135, also known as the Conservatorship Act. My name is Beth McConnell, the Policy Director at the Philadelphia Association of CDCs, and thank you, Chairwoman Tasco, for convening these hearings, and of course the leadership of all of City Council, Councilwoman Sanchez, Councilman Greenlee, in attacking blight. We're going to hear more today from the expert witnesses about how the Conservatorship Act is used, but just very briefly, of course, it's a tool that allows an interested third party, which could include but is not limited to CDCs, to be given permission by a judge to improve a property that's in serious disrepair when the lawful owner is unwilling or unable to bring his or her property into compliance with local property maintenance codes. And as we heard, the act was passed by the state legislature under the leadership of Representative Taylor, who's actually working right now to strengthen that bill in Harrisburg, strengthen the act in Harrisburg. Here in Philadelphia, we need an awful lot of tools in our anti-blight toolbox. As City Council is well aware, I'm going to repeat some numbers that you may be familiar with. We have about 40,000 vacant properties scattered throughout the city, including vacant lots and blighted buildings, of which roughly 30,000 are privately held, privately owned. And the cost of dealing with these properties is enormous. A 2010 report prepared by eConsult Corporation for PACDC and the Redevelopment Authority estimated that the city spends more than $20 million each year in maintenance of vacant properties, including waste cleanup and pest control and police and fire. And that's, of course, a study that was done more than 4 years ago. So the numbers may be higher. And the vacant properties also drain neighboring households of their wealth. They can reduce property values by as much as 20% in some neighborhoods and about 6.5% citywide. And that results in an estimated $3.6 billion reduction in property values, translating in, for each property in the city, about $8,000 in lost value for each household. Now, Council took a very critical step in passing the land bank ordinance this past December to reform the way we get vacant properties back into productive use. And we really think that use of Act 135 can complement the work of the land bank. The land bank will take several more months, of course, before it's operational, but conservatorship can be used today and is being used today. While the land bank has very useful powers to acquire privately held, abandoned, and tax delinquent properties and clear title for potential new owners, doing so for a meaningful portion of the 30,000 properties in need of redevelopment or reuse will take many years, to say the least. And even when the land bank is adequately funded and staffed, it certainly won't have the resources or capacity to take ownership of tens of thousands of new properties overnight. So Act 135 gives organizations that have the capacity to improve blighted properties just one more option. Conservatorship can be a complex and risky and lengthy process and might not be the right tool in many cases. In fact, some of our members, PACDC's members, have looked at whether they could use Act 135 on a few properties, but found that the cost of settling the municipal liens, as well as investing tens of thousands of dollars in rehabilitating the property, would just exceed the property's market value, exposing them to financial loss. So the city might want to explore whether forgiving municipal liens on the properties under Act 135 is a viable option. Additionally, the legal costs associated with pursuing conservatorship through the courts can also deter potential redevelopers, and so it might be worth looking into whether some amount of limited funds or pro bono legal assistance, more assistance could be made available to help. Again, I want to thank you very much for convening the hearings today on Act 135 and continuing the fight against blight here in Philadelphia.
Thank you very much for your testimony. Who's next?
Good afternoon. I'll go next. I'm Cindy Daly. I'm the Policy Director at the Housing Alliance of Pennsylvania. The Housing Alliance is a statewide nonprofit organization that works to increase the availability of homes within reach of...
Speak into the mic.
Sorry.
Thank
That works to increase the availability of homes within reach to all Pennsylvanians, especially those with low incomes. We also advocate for policies to advance community revitalization efforts. The Housing Alliance spent more than a decade working to put more tools into the Fight Blight toolbox. Starting with small tweaks to the state's ancient tax sale laws, we then worked on conservatorship, the blight law known as Act 90, and land bank enabling legislation. These and other effective tools are in our quick guide, which you have a copy of, and also brought you a copy of our conservatorship handbook, which explains the process of using the tool. The conservatorship law went into effect in February of 2009. A few weeks later, the first case was filed in St. Clair Borough in Schuylkill County. St. Clair is a borough of 3,000 people. We have found in traveling around the state that blight is actually the common denominator in Pennsylvania. It doesn't matter if you're in a big city or a small town. The solicitor who represents St. Clair and several other municipalities in Schuylkill County has now done about 14 cases, conservatorship cases, and he has said that in his 30 years of practice that this is the best law he's come across. So what is it that makes it so good? Conservatorship is flexible, as you'll hear from a variety of folks today, and it's relatively inexpensive, at least as far as the court proceedings go. That's not a comment on what it may take to rehab or demolish a property. It also does not put the liability of ownership on the conservator. The conservator has possession of the property and the right to work on it under court supervision, but does not own it. I'll give you a few examples of how conservatorship has worked around the state. I'll leave the Philadelphia examples to later testifiers. The model generally followed in Schuylkill County is to have a buyer identified prior to filing suit. The municipality is the petitioner and the conservator, and the court authorizes transfer of title to the buyer with the promise, with an agreement to do the work after title is transferred. And that relieves the municipality of the cost of doing the work. The buyer gets clear title, which is one of the most important functions of the law. In Butler County, on the western edge of the state, the Redevelopment Authority has done at least 7 conservatorship cases. There they do the work themselves, usually demolition because of the properties that they have chosen. But the demolition makes land available for other uses, including commercial, residential, and side yards. In Columbia County, in the middle of the state, the Redevelopment Authority used conservatorship for an old historic property, for a home. They're currently seeking a buyer who can do the work himself, basically a sweat equity type of case, and they're looking into the legal mechanisms for making sure that the work actually gets done after title is transferred. Conservatorship is a highly effective tool, but it's not the only answer and it is not the answer for every property. Code enforcement should always come first. If code enforcement does not result in compliance, the conservatorship petitioner can use LNI's documents to make the case for conservatorship. Also, the threat of a conservatorship action is a very effective way of motivating an owner to comply with codes or to negotiate a sale. As effective as conservatorship is, there are improvements that can be made. Beth referred to a bill that's currently in the state legislature. Representative Taylor has sponsored House Bill 1363, which will address some of the concerns that practitioners have raised over the last 5 years. The bill will bring most vacant lots within the reach of the law, speed up the process, and make it easier for the conservator to hire contractors that can self-finance. As you will hear, financing the work is still a challenge in many cases. House Bill 1363 did pass the House unanimously. It's in the Senate Appropriations Committee. Other testifiers will talk more about the specifics of conservatorship in Philadelphia. I'm happy to answer any questions about the law's history and use around the state. Thank you for having me.
Thank you very much.
Good afternoon. My name is Judy Berkman. I'm managing attorney at Regional Housing Legal Services. Regional Housing is a nonprofit law firm with unique expertise in affordable housing, sustainable housing, and its related components, community and economic development, utility matters, and preservation of home ownership. We also work on innovative policy matters. The legislative purpose of the Abandoned and Blighted Property Conservatorship Act, which is Act 135, took effect in February 2009. And it uses the police power to provide a mechanism to transform abandoned and blighted buildings into productive reuse. Succinctly, it just basically means that the conservator who's appointed by the court is responsible for bringing buildings into municipal code compliance when owners fail to do so. Since the enactment of the law, conservatorship under this court supervision has become an important tool, as Cindy mentioned, to eliminate blight in Philadelphia. One of the advantages of the law is it's comprehensive because it can be used to revitalize property in residential neighborhoods, commercial corridors, and industrial areas. Also, entering the process is flexible. Many interested parties, which is a defined term in the law, interested parties, which include nonprofits, adjacent homeowners, and adjacent businesses, can petition the court to establish a conservatorship. And the petitioners have to have development capacity and other, meet certain criteria. But like Cindy said, it's important to recognize that conservatorship is only one tool to address blight. So what Regional Housing did, in front of you, you have an orange booklet, which is the best practices and implementation manual. In the back of it is, and it's very detailed, far too detailed, which is why the Housing Alliance made a more user-friendly handbook. But initially, when attorneys were needing to be trained, we developed this handbook so that people could have a comprehensive look at how exactly to go through every step of implementing the law. The back of it includes an appendix with the law itself, and also that we worked as a group with staff at the Court of Common Pleas to come up with what's called a general court regulation, which slightly changed the procedure from what was in the law. For example, the law had service on the owner by certified mail return receipt requested, and the new court procedures adopted by the court require more due process and service of process by a sheriff or advertising if you can't find the owner, things like that. So we also developed trainings for attorneys and for-profit and nonprofit developers on how to use the law, and we worked with licenses and inspections to come up with sample properties of different kinds to take different samples as pilots through the court system because it was such a new law and you were taking owners' rights away. I'm not going to go into a lot of detail. It's in my testimony, so you can look down the bullet points. There are some key provisions of the law, which I'll just point out to you, and then I'll get to a few suggestions for reform that can be done, possibly locally in Philadelphia, in conjunction with the state law changes that are underway. The first set of bullet points shows who can be a petitioner. And we have several petitioners in the room. They could be a for-profit, a nonprofit, like I said, an adjacent homeowner or business, and the redevelopment authority. Then there are 9 criteria set forth in the law, and you have to meet at least 3 of them to have a conservatorship name for a property. Public nuisance, it needs substantial rehab, it's unfit for human habitation, it's a hazard of various kinds. And in the manual, we went through in great detail how to meet the burden of proving many of these requirements. In addition, as you might imagine, there are some basic conditions. It can't have been legally occupied. That doesn't mean if squatters are there that's legal. But we don't want to have, it's only for abandoned property, and that's for 12 months. It can't have been actively marketed for sale. It can't be subject to a foreclosure. It can't have a new owner within the last 6 months, that kind of requirement, so that we're not interfering with other people's rights, as well as it can't be used against someone who's actively deployed on military service, and it can't be used against the housing authority. So once a property is identified and an eligible party is ready to proceed, the court takes over, the petition is filed, and the court has something that's not in the law, but the local courts have been very flexible about having a status conference first to bring parties together to talk about it. And then there's a preliminary a hearing on the preliminary plan. At that point, the conservator is not yet appointed and can't enter the property except on certain circumstances with court permission. So it's sort of a wild stab as to what's needed. Then the conservator's appointed and has authority to go in the property and start making the plan that then goes back to the court to get the final plan approved. And all along, people are given notice about all the steps that are taking place. As a result of us, the Regional Housing's implementation manual, which is posted on our website, and all the trainings, I've been getting a lot of questions. I get regular questions a few times a month from for-profits, nonprofits, neighbors, people asking questions about particular properties in their neighborhoods that are blighted, and they want to consider using the conservatorship law. And so it's been interesting to have, then I look up online because there's so much information available on the city's website, a lot of information about it. Often there are municipal liens, which is an immediate obstacle to proceeding. So while the Pennsylvania legislature is considering amendments to Act 135 that will help expand the use of the law and make it easier for us to use it in Philadelphia, I've also observed a few points I'd like to make in terms of improvements that might be able to be made locally. One is funding. Right now there's really no source of funding unless there's an investor available or the conservator can get a line of credit, because we've asked a lot of commercial banks and they won't do lending, and it's just not possible. One reason is compared to Ohio, where federal liens are the only liens that would be ahead of the conservator's lien, in Pennsylvania it's federal, state, and local liens that are ahead of the conservator's lien. So anything the conservator does would be subject to federal, state, and local liens. Generally, there are not federal or state liens, so it's the local municipal liens that are the obstacles, and people don't want to be behind that in lien priority. And I give an example in my testimony of what they did in Massachusetts to try to form a collaborative, a way of giving funding in a line of credit to people doing conservatorships that then is repaid to that funding source. So one idea is to bring together stakeholders and see if we can put together a funding source for conservatorships that could pay for the attorney's fees and costs related. Sometimes service of process has to be advertised, that's expensive, as well as the remediation work. And then if we could recycle that money back into a fund, it'd be good to have a pilot program or some initiative pulling people together to try to form this kind of funding source. Again, I'm mentioning the municipal liens. It's just an impediment, and if the city could, either as part of the pilot program or a general policy, waive the liens, or at least come up with criteria for how they would waive the liens for certain kinds of properties, that would be really appreciated, because so many people who call me up and I look online and I can see that there are real estate tax liens, and I tell them how much, and in the neighborhoods they're working in, it's just, they can't go forward, because after they would put the money in, they'd never get their costs back. And the final suggestion I have is something that may be being worked out as a practical matter, but needs probably some city council action. Some of the terms in Act 135 are inconsistent with what's in the city code. For example, public nuisance is a term in the Act 135, but I think it's nowhere in the Philadelphia Code. So doing an analysis of the Act 135 language and seeing where definitions need to be defined, this means public nuisance. If it meets these criteria, it means it's a public nuisance for purposes of Act 135. That kind of thing could be very useful, because it's hard to use L&I violation if they don't have the same language that's in the code. So thank you for the opportunity to testify today and provide you with information. And I was once, someone in California once was interested in what was going on in blighted and abandoned property in Philadelphia, and they Googled Philadelphia and abandoned and blighted property, and my name kept popping up. So I would like more use of this law so that I am not famous for such an issue.
Good, Judy. Thank you all very much. Chair recognizes Councilwoman Sanchez.
Yes, quickly, and I know they're coming to testify, but I wanted to ask Cindy, in the implementation in the other counties, what is the role of L&I and their redevelopment authorities in this? That may be different from what we're doing here in Philadelphia.
The main difference, I think, is where Philadelphia and Pittsburgh have strong and active community organizations, most communities, most towns around the state don't. And so the redevelopment authority has taken a more active role in, as I mentioned, Butler County, Columbia County. I'm trying to think of where else they might have done some. So the redevelopment authority or a nonprofit affiliate of the RDA steps in to take that role. And in other places, the municipality itself has done the work. But in places like most of the towns in Schuylkill County, which is coal country, a few counties northwest of here, there just aren't any community groups to take that role. So I think in Philadelphia, having the strength of the neighborhood organizations that you do, it's appropriate for them to be involved as well. But I know that the the redevelopment authority, is stepping up and doing some, looking at conservatorship also.
Okay. Judy, related to the municipal liens piece, essentially what you're saying to us is there's not a policy for the city has not articulated a policy around if people are using the conservatorship.
It's my understanding the official policy is not to waive the liens.
Under any conditions.
There may be certain case-by-case times when they have, but my understanding is that the official policy is not to. So it would be good to have criteria for when they would or wouldn't, or to parallel the land bank, which you're so well aware does resolve the municipal liens. It'd be good to have maybe a parallel process that's similar for this, if that could be worked out.
Thank you. Thank you for highlighting that. Any other questions?
Thank you all very much for your testimony. Oh, I have a question. What would be the range of the cost for a pilot? I think you talked about that.
I guess I would have to defer to some of our later panelists.
Okay.
Rick
All right.
Vanderslice has handled a lot of these, so I know in Massachusetts they were only remediating the blight, and I think their line of credit from a few years ago when I worked on it was $50,000, but it may not be enough here.
Mm-hmm. Okay, thank you. Thank you very much. Our next panel will be John Unger from the Mighty Northwest, CDC, or Anuj Gupta from the other part of the Mighty Northwest, Vermont area, USA, Vic Vanderslice, Esquire, Richard L. Vanderslice, PC. Yes. Thank you. Thank you. Do we have Joel Palmer, and CEO Scioli Turco? Okay, you can sit right there in that chair, and when your time comes to speak, you'll move over to the desk. Okay, thank you. Good afternoon. Who's going first? You go first, John. Okay. State your name and...
Sure.
for the record.
Good afternoon, everyone. My name is John Unger. I'm the Chief Operating Officer of the Ogontz Avenue Revitalization Corporation, or ORC, and just want to state up front, my testimony may sound very familiar because the councilwoman very eloquently told the same story about Artie, so please bear through my testimony. But I think it's just a compelling case, and obviously councilwoman feels the same way. It's a great example of how powerful this tool is. Anyway, ORC is a 501c3 nonprofit community development corporation located in Northwest Philadelphia. We were founded in 1983 by Pennsylvania State Representative Dwight Evans, specifically to address the problem of a blighted shopping center on Ogontz Avenue. Work has grown significantly since then. Our mission is to create and stimulate economic development and improve the quality of life for residents of West Oak Lane, other sections of Northwest Philadelphia. We've been engaged in community economic development work for over 30 years now. Some of our accomplishments include the redevelopment and management of over 400,000 square feet of commercial and institutional space, the rehabilitation and management of approximately 50 units of affordable rental housing, rehabilitation of several vacant homes which we made available to first-time home buyers, establishing the West Oak Lane Charter School, completing a major streetscape project on Ogontz Avenue, providing housing counseling services to approximately 1,000 people a year through our housing counseling division, and of course the West Oak Lane Jazz and Arts Festival, which in its heyday attracted hundreds of thousands of people to our community every year. Basically, I'm here to testify in support of the expanded use of the Conservatorship Act, and basically I'm going to share our experience with the Act. Just near the corner of Ogontz Avenue and Washington Lane, as the councilwoman mentioned, which, by the way, is it's a major intersection on Ogontz Avenue, which is the heart of our commercial corridor. There was a one-story commercial building, which she identified as Artie's, and it sat abandoned for many years. I started working at ORC in the late 90s, and as long as I was there, everyone you ever asked said it's been abandoned for so long. No one knew exactly, but it goes back at least to the 1970s. As I mentioned, we started our revitalization work in the early 1980s. First with the shopping center. We purchased several properties ourselves and redeveloped them. We helped several other business owners with facade improvements. We provide street cleaning. We've planted trees. We've done a redevelopment project, streetscape project with new crosswalks, sidewalks, pedestrian light scales, light poles. In general, really brought the avenue back and once again made it a desirable place for businesses and shoppers. However, this one significant building eluded us. We had tried many times in the past to purchase this building from the owner, but the owner always wanted an astronomical amount. I'd been told even upwards of $1 million, probably because the owner was aware of our redevelopment efforts and thought, oh, these folks will just pay me whatever. It just sat there like a black eye in the community. So finally, as the councilwoman mentioned, although the property owner did not take care of the property, it was a one-story building and an adjacent parking lot, both of which were completely dilapidated, he did keep up on the taxes. So before this law came into effect, there really were no means to force the owner to the table. We couldn't bring it to sheriff's sale. There was really nothing else we could do. It just sat there, this person making unreasonable demands, trying to get a windfall on the community's back. Fortunately, in 2008, the state legislature passed the Abandoned and Blighted Property Conservatorship Act. So finally, there was a tool which enabled nonprofit organizations and concerned citizens to tackle properties which were blighting their communities, even if the properties were not tax delinquent. We knew this was our only chance to develop the property, so we reached out to the Regional Housing Legal Services, who in turn put us in touch with the law firm of Morgan, Lewis & Bacchius. Morgan, Lewis & Bacchius took our case on a pro bono basis, and we filed the first conservatorship petition in the city of Philadelphia. Now, happily, we didn't have to even go through the entire process, because finally there was a means to bring the property owner before the court and force him to do something. The petition was filed, hearing was held, and all the parties met the judge. And I want to say, by the time we got here, this property was in such horrible shape. Half the roof was gone, the parking lot was a mess, the floor was rotted inside, it was infested with birds and other animals, and I actually have some pictures. This is what, on the outside, doesn't look all that terrible, and I'll submit it to the council later. But you'll see on the inside, there's really nothing left. This is definitely what qualifies as an attractive nuisance, a danger to the community. And this is a man who wanted about $1 million for this property. Anyway, I said, by the time we got to court, the property was in that condition, and a meeting was held with the judge, and the property owner realized things were not going so well for him. The judge was inclined to grant our petition, so finally he started talking real-world numbers. And we had initially offered $200,000 for the property. He wanted the property appraised, and we said, sure, we will pay for an appraisal, and we will pay you the fair market appraisal value of the property. Well, fortunately for us, the appraisal came in at $175,000. So we kept our word, and we paid him $175,000. So again, this is just the power of this process. The community got the property at a fair market price. The owner received fair compensation. I think it's really important to mention that. The owner did not get his property taken away from him. And since then, about a few years ago, we sold it to an entrepreneur developer, which is the Tang family, opened up actually they tore down that building, constructed a brand new building, resurfaced the parking lot, landscaping, signage, and now it's their 5th pharmacy in the city, along with 2 other offices, 2 medical offices. So before, whereas you previously had the property taxes being paid, but a blighted, influenced the community, now property taxes are paid, there's no blight, there's UNO, there's payroll, there are jobs. This is a contributing parcel in our community. We're obviously thrilled. I want to add that ORC once again has an opportunity to use the Conservatorship Act, and I think once again this is a situation where it may be our only viable tool, so it's critical that we continue to support this. We're working to do some development further down on Ogons Avenue, close to the Ogons branch of the Free Library, and there's about 4 or 5 properties all in a row owned by one person or the family, and some of them are behind the taxes, although at least one of them is current in the taxes, so couldn't bring it to a sheriff's sale if we tried. Just last week, one of the corner properties collapsed. And we met with L&I, and they're very concerned about this as well. We've been in negotiations with the property owner to buy these properties, but our concern is that since the other properties have taxes on them, I ultimately think this property owner is not going to be interested in a direct purchase, and I think that conservatorship is going to be the only tool we have available. So once again, we're very happy the tool is there. I support the expansion of it. Just thank you. It's a fantastic tool. It's important in fighting blight.
Thank you very much. Every time I go there, I said, that's our conservatorship.
Madam Chair and members of the committee, thank you for holding this important hearing on a matter that I believe, with some improvements, could offer a citywide solution to our longstanding problem of blight. My name is Anuj Gupta. I'm Executive Director of Manor USA. Manor USA is one of Philadelphia's more comprehensive community development corporations with a focus on housing counseling, corridor and business district revitalization, a public school improvement initiative, and real estate development of affordable for-sale and rental housing and affordable high-quality commercial space for small businesses. It is our real estate function that brings me here today. For years, Manor USA has been rehabilitating vacant blighted properties, untouched by private developers, into new affordable housing opportunities for low to moderate income Philadelphians. However, the City of Philadelphia has over the past 2 years eliminated most of the funding programs that allowed this work to continue. High construction costs in Philadelphia make it difficult to develop high-quality affordable housing or commercial space in areas where the market values are not high. Therefore, to continue this much-needed work and to finally utilize an effective tool in the fight against blight, Manor USA has turned to using Act 135. Act 135 offers Philadelphia its most effective tool yet in remediating blight. Not only does it put negligent property owners in a position to either address their property code violations or potentially lose their property, it can also allow a CDC like us to move quickly in addressing a problem property. By way of example, in May 2013, Manor USA filed its first petition to address a long-standing boarded-up vacant property at 59 East Philolena Street, which you have a picture of in its initial state, should be with your files. This property was owned by a corporate investor with a suburban address who had no interest in caring for the property and was tax delinquent. In December 2013, merely 7 months later, Manor USA received its final order from the court to enter the property and begin rehabilitation. Construction is now nearly 60% complete, and by early April, a brand new housing opportunity will be available for a new homeowner.
And where is that?
I'm sorry?
Where is that located?
At 59 East Philolena Street, so about 75 yards in from Germantown Avenue. A new housing opportunity will be available with stainless steel appliances, energy-efficient windows, hardwood floors, etc. As a veteran of city government, I can say with some measure of confidence that no current city vacant disposition process can move that quickly. Having achieved our first success, Manor USA is now determined to replicate this and aggressively address blight throughout our community. There are a number of steps city government can take to make this more feasible. Number one, many properties eligible for conservatorship are upside down. Because the statute requires that all governmental liens be repaid first from sale proceeds, the amount of liens on some properties plus the construction costs exceed any reasonable expected sales value. To date, the Department of Licenses and Inspections has been an excellent partner in not only citing properties for code violations, but also working with potential conservators to discuss reducing outstanding liens to make the economics of rehabilitation work. Unfortunately, other city departments have not followed suit, and it has been difficult to generate any interest. To truly unlock the potential of conservatorship, the Revenue Department, Water Department, and Gas Works should all follow suit. We are not asking for unreasonable waivers or reductions of liens, only enough to make the redevelopment of the property work. Number two, the city must stop taking a short-term view towards vacant blighted properties. In June 2013, Mount Airy USA had prepared a petition for conservatorship for another property that is a long-standing eyesore in our community. The back of the property was on the verge of collapse, and a rear detached garage may come down altogether in the next storm. Before filing the petition, Mount Airy USA learned that the city was intending to begin tax foreclosure proceedings on the property, a step that would put a halt to conservatorship. When Mount Airy USA requested the Law and Commerce Departments to delay the tax foreclosure process to see if the property could be acquired through conservatorship, Mount Airy USA was told the city would not stop and that the impetus for generating funds for the school district was too great. This is a short-sighted approach. While a tax foreclosure may generate some immediate relief for the city and district, it does nothing to ensure that the property is redeveloped. Conservatorship would have required not only the repayment of outstanding liens, but under court order would have required the property to be rehabilitated. Now, because of this short-sighted decision, the property continues to sit, deteriorating, presenting a nuisance and blight for the surrounding neighbors, and a significant safety concern. City policy should shift to prioritize conservatorship applications over tax foreclosures, as conservatorship will ensure the repayment of taxes and that the property is put back into productive use. 3, finally, as mentioned, all of the city's subsidy programs to develop affordable housing in areas where the market is not working have largely been eliminated. This includes the HRP program, the Targeted Housing Preservation Program, and the Neighborhood Stabilization Program. Council should work with the administration to restore some funding for this important work by community development corporations, either through funds slated for construction or general operating funds. Madam Chair, as you know, all of the CDCs in Northwest Philadelphia, a significant portion of our city, are currently disqualified for any CDC funding from the Department of Commerce because of their interpretation of community development block grant rules. Together, with the land bank, we now have the tools in hand to reverse the ravages of blight throughout our community. With a few easy changes, we can now amplify the impact of Act 135. Let's not allow blight to consume any more of our neighborhoods. Let's put this law to work now. I appreciate the opportunity to provide this testimony and would be happy to work with your office moving forward to address these ideas.
Thank you very much. We'll let the others two testify. I want to come back to this, their testimony. Go ahead, sir.
Thank you, Madam Chair, member of the council. My name is Richard Vanderslice. I'm an attorney in private practice, and I have had the opportunity to represent some of the first movers as far as implementing Act 135, including the nonprofit Shirley Turco, as well as Mayfair CDC, Bridesburg CDC, several private entities, including Stephen Ehrenholt, Universal Building Corporation, and Streamline Solutions in taking a tact that is allowing private individuals and smaller nonprofits to implement the act to affect change one building at a time in their neighborhood. First, it was touched on earlier, but I would like to say that the Department of License and Inspection's vacant property strategy has been an invaluable resource for the private and nonprofit entities that have been putting this into use. It helps us bring our case in that we can have testimony from both the inspectors who have been out to the property, as well as for a time we had an inspector that was designated to testify and could bring light to the court as to, how these properties generally progress when they're left to the owner's own devices. Secondly, I would say that the court has implemented a fair and expeditious manner in which these matters have been handled. Often a respondent or the defendant in a case levies the charge that it is a land grab, which I think previous testimony did a good job of clarifying that, in fact, the owner remains on title and has the opportunity at most stages of the process to come back in and do the right thing. Finally, once the rehabilitation is complete and a potential out sale is completed, oftentimes the owner realizes proceeds from the sale of the property where it normally would have been taken through tax sale and they probably wouldn't have seen anything. Or the liens from L&I demolition would have taken away any value to the vacant parcel. So in most cases, it is a win-win. And it's funny that Artie's has been mentioned. I attended that hearing as I had filed the second petition and was anxious to see how it would progress. And one of the factors is that not factor, but the owner made the argument that the property was not abandoned. And when the judge turned to him and asked him why, he said, well, I walk by it once a week, so I haven't abandoned it. Now, as you can tell from the photos, especially of the interior, I don't think anyone here would argue that it was abandoned. And believe it or not, I've, in the course of proceeding with around 50 of these cases, have heard even more interesting explanations of why their property was not abandoned. But that is where the court has come in and where a little bit of funding could go a long way. Often these homeowners, if they haven't been to blight court, or even when they have, they've found that they can get away with keeping their property while, technically barely in compliance. It still would, by any definition of the word, be blighted and vacant or abandoned. But when we get some of these homeowners to court and they see that, they're not going to be able to dance around and the judge really does a good job of bringing them to task, they realize that, A, we're going to take over and do it if they don't, and B, that they're not going to be able to get any kind of, half measure past this process, which, for the slight investment of bringing it to court as opposed to what it would take to fully rehabilitate a property, or even the city resources it takes to finally get a property at a tax sale, I think the cost benefit weighs very heavily in favor of conservatorships. An example of where funding would be beneficial beyond the stages of bringing a petition. There's currently a petition pending and awaiting approval of a final plan on a property in northeast Philadelphia. It was filed by the Bridesburg CDC. That property was gutted by fire. The owner just basically left it to rot. Unfortunately, the costs of a private developer rehabilitating in addition to the liens on the property make it somewhat prohibitive to complete a full rehabilitation under the conservatorship process. Now, if there was a grant or some sort of loan guarantee that the city could provide, that would definitely make that project feasible and fully restore that property. But, as has been mentioned, the nice thing about the conservatorship process is it's flexible, and we are trying a new approach with the court that hopefully will get it into the hands of a local person who can bring about a restoration of the property, although not with the alacrity that a conservator may. In regards to the point that was made about abating city liens, there's a property on Fitzgerald Street in South Philadelphia that has a little over $45,000 in tax liens. I believe there's a good portion of that is water and sewer, and I imagine there's a PGW lien that hasn't been recorded. But the difference between making that project full green light and trying to figure out what we're going to do with it is principal and interest on those liens. So even a citywide policy for conservatorships in regards to negotiating the principal and interest on liens would do immeasurable good as far as breaking one of the log jams that have held back these cases. I have consulted with several, especially private neighbors of these blighted properties who, when faced with the prospect of having to fund the rehabilitation themselves and without the prospect of having commercial lending available, and only a hard money private lender possibility with the higher interest rates have not seen themselves as having the ability to take on that property that's next door to them, causing not only damage to their property, but bringing down the value on the property in the rest of the neighborhood. This is what we commonly refer to as the broken tooth. The rest of the block is in great shape, but there's that one property that someone's just let go. I know we've all seen it in Philadelphia. But again, in these situations, bringing them to court can be two-thirds of the battle, and even funding for that endeavor would bring about a lot of change in these types of properties. As Ms. Berkman mentioned, amendments to the property management code that track with Act 135 would also be very helpful in proving the case when it comes to court. Often it takes costly expert witnesses to prove that a property is a fire hazard. Now, you can look at a picture of some of these backyards with the weed trees and trash, and you know that that's could catch flame on any droughted summer afternoon. You can look in and see all of the trash and see the open windows that have let rain in there, and you know that that property is going to be a hazard for first responders. But without evidence, either through expert testimony or even better, a citation from the Department of License and Inspection saying that it has been deemed a fire hazard by the city, it can be very costly to make that case and satisfy one of the factors that is required to prove that a property is blighted and allow it to be taken into conservatorship and rehabilitated. One final suggestion I would have is, and was touched on by other testimony, is the tax sale procedure. I can give you an example of a property in South Philadelphia that was filed on, and I don't think it was even a week later, one of the law firms that represents the city in tax collection filed their notice of sheriff's sale. I don't know if any of the council members have tried to find information on whether or not a property is going to sheriff's sale, but it's not always as transparent as one would like. Long story short, the property went to sale, and it's been 6 or 7 months now trying to negotiate with the successful bidder as to what's going to happen with the property. This could easily have been avoided if the firms that sell these properties were required to do what's commonly called a bring-down title report prior to the sale. This is merely asking the title company, hey, what's happened in the year and a half, 2 years since we filed this case initially? That would pop up the lis pendens, which is a notice of court proceedings that are required to be filed in conservatorship cases, not to mention any other liens that have been filed, which anecdotally at least, I know cost an immeasurable amount of time on the part of the law department when they could be doing greater good as far as collecting revenue for the city. So with those in mind, I would like to thank the council for the opportunity to testify about this important tool that I have seen revitalize many properties in the city, either at the hands of a conservator or a property owner who has come around to the standard that they should be maintaining their house to. Thank you.
To do. Next, Mr. Palmer.
Madam Chairwoman, thank you very much. Thank the council for the opportunity. I'm Joel Palmer. I'm the Chief Executive Officer for Sholey Turco. We are a 501c4 corporation as a conservator for blighted properties. Based on a most recent tally, we've filed more than half of the Act 135 actions in the Court of Common Pleas in Philadelphia and feel qualified to speak about the law. At the risk of, or not to be cumulative to the other testimony you've heard, I would like to ask that if the City Council could, they codify what is now an ad hoc practice of the Law Department, which is to abate the interest, penalties, fees, and others on the taxes owed on these properties. As Mr. Vanderslice and other witnesses have testified, that sometimes makes the difference between whether a project can be accomplished equitably and with a fair return or not. And currently it's done on a case-by-case basis, but I think it's something that the City Council could easily put into a code, and then it would be done automatically. If the City Council could also urge the Pennsylvania Senate to act without delay on a bill that I believe has no opposition, and that is the amendments to Act 135. Representative Taylor's office, and you'll hear from Mark Colezo later on, have fine-tuned and streamlined some of the parts of the act that weren't working very well. That has passed the House. It is in the Senate. I think I speak correctly in that there is no opposition to this amendment, but the vote on it has been delayed, and until it's voted on, passed, and then the governor signs it, it doesn't do anybody any good. Third, if we could achieve some sort of a waiver or a deferral of witness fees that are paid to licenses and inspections. We call them as expert witnesses and pay in advance. And since 99% of Sholey Turco's costs are our legal costs in bringing suit on Act 135, it becomes a bit of an impediment. L&I has been a stellar department in working with us in providing witnesses and testimony. We'd like to be able to settle those charges, if they're appropriate, at the outsale of the property and not in advance. Lastly, I'd like to thank the drafters of the legislation and Judy Berkman and all the organizations that work to implement it and create handbooks. Sholey Turco is at the tip of the spear. We actually file these cases, take them through court. I have a son and two brothers that are attorneys, and I've spent enough time in court to know it is often a very thankless job. And so we appreciate the opportunity to speak with you today and to ask for these few things.
Thank you. Thank you very much for coming down to testify. Before you leave, Aruj, you talked about the CDCs in the Northwest are not, have been disqualified for CDC funds. Could you give me a little more information on that, please?
Thanks, Madam Chair. So many of the remaining funding programs that are available to community development corporations in Philadelphia, largely through the Department of Commerce, rely entirely now on federal community development block grant funds. There are no city general revenue funds put towards those programs. The administration's interpretation of the use of those funds and what sections of the city qualify for their use have essentially cut off most of Northwest Philadelphia, including communities served by ORC, Mount Airy USA, East Falls, Roxborough, Manayunk, am I leaving anybody out?
Chestnut Hill.
And Chestnut Hill, of course. That's not to say there isn't need. There's tremendous need. You certainly know the need in your district. Around our office, there are any number of blighted properties on Germantown Avenue, on the residential streets around Germantown Avenue, and the other folks in the other communities need help as well. But right now, there is no opportunity to apply for support from the Commerce Department, largely. The consequence of that is any dollar that we have to put towards operations to keep the lights on is a dollar taken away from potential construction capital. We would like to be able to expand our use of this, and right now it is entirely constrained by capital, how much funding we have available, and how much we can put towards construction. So that was my general reminder, if you want to add.
As a result of that, ANUJ and ORC and other CDCs have actually formed a coalition, the Northwest Commercial Corridor Coalition, and we've met with a number of council people as well as Alan Greenberg with the Department of Commerce, and we have suggested that the mayor put into this year's budget $1 million, I believe, to be allocated for all the CDCs that don't meet this eligibility to compete for that, on a competitive basis through a grant process. The Commerce Department is in support of it. Basically, we have a lot of support, but it all depends on what's going on with other financial constraints. But as you know, we can, in these communities, we can leverage the dollars a lot. We can get a lot done with a little bit of money. So the process has been going on for probably about a year now. We came to the table a little too late in last year's budget process. We learned from that, and we're a little bit ahead of the game now. So hopefully this will change going forward.
I'm just going to make this comment, and we'll go to the next panel. It's very interesting. When I did my first meeting some years ago with the National League of Cities, and when I came to council, it was very difficult to get money for my district because it was all targeted to, based on the income levels of residents in the neighborhood. So I go to the National League of Cities, and they're talking about the community development block grant dollars, and they talk about Tennessee, and they're building boat slips. I said, boat slips? Golf courses, okay? So what we're going to do is we're going to check with HUD on the regulations, because I think there may be regulations that were set up by Philadelphia and not national regulations.
Thank you.
Thank you. I'll be down there next weekend, and I'm going to check that.
I have a couple questions.
Councilwoman Sanchez.
Yeah. I applaud you for doing that work. One of my challenges every year when we talk about CDBG funding is how we limit the capacity of you guys to leverage it because we're using CDBG dollars as opposed to general operating. So I'm glad to see that, and hopefully that $1 million will be on the table. I think that all the money that we put out in the street should be general operating, and then that way we release all those federal regulations until we figure out the federal policy, from the street cleaning to the corridor management. One of the things that happens is we set up these good programs. I know the Mixed Commercial Development Fund money, there's a lot of it that's just in the pipeline because of the regulations. So I'm glad that you guys are advocating for that, and I think the councilwoman and I know other district council folks, my district meets all of the eligibility requirements, but I don't think it's a good utilization of staff administrative time to ensure that we're meeting all the federal benchmarks. I just think that it's not good best practices internally. So to the extent that we can free up that money, I think it will help the entire city. And I think the times have changed. We now have a trash fee. We want to be able to tell folks that trash fee is going back into your neighborhoods. It's a perfect example of where we want to see it used. So I applaud that and be happy to kind of work with you. I know that's an area that I continuously challenge, the administration around thinking about how do we free up the regs so that you guys could do the work that you do. And I think that's a good one to target because it's an easy one. It's a no-brainer one to do. And we'd be happy to do that because then you're expanding the pie. We're not fighting for the same pie. It's about expanding the pie. So I appreciate that. I just want, for my recollection, because all of you have dealt with this, what I'm getting from here is that some of the things that we can do locally. I mean, obviously, the state level, I think there's some good amendments on the table, but we try to link this up with some of the stuff that we're doing with Land Bank. The policy for the forgiveness of liens is one that is because you guys have asked us for a bunch of stuff, so you guys got to prioritize this. Got to figure out which one's first, which one's second, and which one's third. I have absolutely no problem in saying,
We can multitask.
I know we can, but the administration's going to tell us, I don't want to give them the low-hanging fruit. I want to give them the one that's the most complicated. So as we debate this, is the policy for forgiveness of loans, obviously we have that now, and you guys in the CDC world have helped establish what those rules are around affordable housing. Do you foresee a situation where coming up with a policy and having some limitations around affordability or accessibility would be a problem for any of you that are doing conservatorship projects?
That would not be an issue. I mean, we develop our homes to sell to low and moderate income Philadelphians. And these are middle-class people. They're working, they have jobs, they just want a good home at a decent price. And just to give you an example, the Neighborhood Stabilization Program, which was administered by the Redevelopment Authority for many years, we redeveloped 13 vacant properties through that program. Our average time to market from the time we listed it to the time it went under agreement of sale was 5 days. And that was during the depths of the recession. So that said to me that there is simply not enough reasonably priced, decent housing out there. And that's what we're trying to accomplish. So for my
only
say
thing
we have no.
is it's the easiest to go to because there's a current policy in place to that.
Yep.
So it's about applying it to this definition of conservatorship. But, if we're going to go too far out there, then obviously the administration is going to have to weigh this in. But asking them to apply their current policy to this category is easy enough. Or I would think that's easy enough because we're being consistent in our policy. Over here we always try to be consistent in our policy. So I just want to make sure that that's something, and it would be great for there to be some sort of formal piece by the CDC world, Beth and the folks to say, under a conservatorship policy, the current policy is adequate, and I think that helps us move that along. I think that's important. I think one of the things around aligning of the codes for L&I think for us it would be really important for someone to work with L&I and figure out, we just did the whole property maintenance code. I know that we have to do some additional stuff, but to the extent that there's a working group that provides what that language is, I know the commissioner would be interested in helping facilitate that. We just need to know what that looks like.
Councilwoman, if I may, the real property section of the Philadelphia Bar is working with,
Okay.
I believe we've reached out to, I'm not sure who our lobbyists are reaching out to, but we're trying to convene a task force to do that. And I think the purpose of bringing that up today was to put that on the radar as one of the ideas while we're doing that. And if I may speak to your question about abating or reducing the municipal liens, I've represented quite a few private developers who could also benefit from at least an abatement of the interest and penalties. And these are, at least so far, guys who are working on Hazard Street and up in Brewery Town to try and, bring around some of those neighborhoods to bring them back to productive use. Right now there's one pending in Brewery Town where, it's guys from D.C. who bought it as an investment property and have been sitting on it for 10 years. Meanwhile, my client's been developing a significant number of the properties in that neighborhood, and these properties are the last ones there that are holding up this neighborhood from being as vibrant as it could be.
Well, I think this is one of the times where we got to think outside the box. I'm not going to sit here and subsidize a private developer, but I will subsidize a potential homeowner, affordable homeowner.
Or a
so I think
nonprofit.
it's how we word that, and that's why it's important that we have the same framework in terms of who do we want the deal to work, but I want the deal to work for that person who's going to live in that house. So how we get there, we can kind of talk about it. But I'm open to that as long as we're clear. I mean, I think the PRA has been very creative, and I'm sure Brian will speak to this around, do you soft lean some of this stuff to assure affordability long-term, where we're trying to get to in 20 years, so that lien is on the property so people are not buying it and flipping it on us.
Right.
So that we can meet the mutual goal, particularly if the city is going to subsidize, because a forgiveness of a lien is a subsidy. We may not have the cash, but if we have the equity, we should be willing to put it on the table. Again, assuming the end user is the person that we want to help, and that the subsidy goes to that person, not necessarily the private developer. And then in terms of offsetting of some of these costs, has anybody had a conversation with our Office of Housing and Community Development about Housing Trust Fund support around this? Because I know they've been redefining that kind of stuff. Has anybody said, can we create a pilot, going back to what Councilwoman, what does that pilot look like? And do we use Housing Trust Fund money to create that under kind of the 10 different names we had on there? Brian will list them all for us when he comes up. So no one's done that yet?
We have not.
Okay, thank you.
Thank you very much. We had a facility in my neighborhood go from sheriff's sale to a private owner, and now it's just sitting there. So we got to figure out how we deal with that, because, it's very important. And I think we've done a lot of work in a number of communities in this city to stem the blight. And certainly I have to take pride in the Northwest with the Mount Airy USA and ORC. And certainly if we hadn't had support and subsidy from the city, which I think they have a responsibility to do, because the neighborhoods are just as important, we would have still had a blighted Ogons Avenue. So, but through a lot of different means, and certainly support from the city, we've been able to, revitalize that neighborhood. And also, we just had this Pew study about the middle class. And certainly those neighborhoods are middle-class neighborhoods. So if we don't maintain them and revitalize them and keep them in a situation where people want to live in that neighborhood, we're going to lose them. So I think we have a responsibility to find a way to stem the blight. So I thank you all for your hard work, and thank you for coming down to testify. Let me recognize Councilwoman Cindy Bass, who has joined us, and she has a question or comment.
Thank you. I just really wanted to weigh in on Councilman Tasco's comments and just also echo them, because I know, I know what the Northwest used to look like, particularly from Mount Airy USA and Fort Worth, before the work that you did. I know what it looked like. Anush, I was, worked for Mount Airy USA and have been very involved and have been involved for a long time. And I can see the difference, and it makes such an incredible difference when you have partners and partnerships that we can work with. Certainly we as members of council can't do this work alone, and so I just really wanted to say on record that I really do appreciate you and the work that you do, and John, of course, with ORC and the work that you all do, and we've been working very closely together. When you drive down Ogons Avenue, you can see, it's clear, it's visible, and I think that's what sells, and people get it when they see it. So I just really wanted to weigh in and thank you all for the work that you do in the Northwest.
Thank you. Thank you all very much for your taking time to come out to testify and provide us with some good information, and we can see where we can, help with the Representative Taylor on that piece about the code. Who was talking about that? Act. Yes, I wrote that down. Okay. Our next panel will be Brian Abernathy, our Executive Director of the Redevelopment Authority, Rebecca Swanson, Policy Director, License and Inspection, and Mark Colazzo, District Manager, Office of State Representative John Taylor, who's I was so happy when I heard he did this.
Thank you, Councilwoman.
Okay.
He didn't say it about you.
No, I wouldn't blame you.
Listen up.
You want to go first? You can go first.
Thank you, Brian. Good afternoon, everyone. I want to thank you, and I think I'm speaking for everybody here, for convening this hearing and really looking into this issue and how Act 135 can be utilized more frequently and more efficiently. I know when Representative Taylor...
First, you have to identify yourself.
I just realized that as I was talking about me. Mark Colazzo, Chief of Staff and District Office Manager for State Representative John Taylor. Thank you, Councilwoman. That when Representative Taylor introduced this law back in 2008 and ultimately passed, the goal was obviously broad, how we can take these blighted, vacant eyesores and get them back into productive use, both by people utilizing them as well as getting the tax rolls more fluid and flowing again. And when I was fortunate enough to come aboard with Representative Taylor in 2010 to help run this, what you found is very little people knew about it. And ultimately, I joke that we're sort of like this traveling band that whenever Act 135 comes up, it's all of these people here. So we sort of have our little shtick down. But so it is a pleasure. And one of the things that's what we have found, and I'll kind of talk about the amendment that is passing, House Bill 1363. I think you all know just by having here the benefits of what Act 135 can do. Since it's been utilized by the many people in this room, and certainly I've got to commend my colleagues to my left here. Elle and I have certainly taken a leading role. There's really been a lot of symmetry with the administration, with council, with Elle and I, and targeting those vacant properties, issuing violations so that when we go to file, we can have our proof to show blight. And I really have to commend them. And I know Mr. Abernathy will be speaking on the efforts they're doing and the filing they just made. What we found is like anything with any law, it's trial and error, what works and what doesn't. And what we really wanted to do, one of the things we really found in the filings were our groups were filing, whether it be CDCs, whatever entities, that once they're being filed upon, the owner or whoever's acting on behalf of the owner rushes to make a deal to sell it. And that is great ultimately because what the judges have been doing is you can sell it, but you're going to make the changes or the renovations that were requested by the conservator. So the community benefits, there'll be a new homeowner because there's, and so that's great. But where does it leave the petitioner? Because as we know, these things cost money. And they become less cost effective when people are putting money out of their pocket, getting someone to court, getting a desired goal, and they're not really getting anything. And that's really what led to House Bill 1363, which was presented on May 8th of 2013. As you know, conservatorship is the appointment of a third party to take control of a blighted and abandoned property and to make the repairs necessary to return the property to productive use. A Court of Common Pleas appoints the conservator after a formal petition process and hearing, including notice to the property owner, all lien holders, and all political subdivisions where the property is located. Representative Taylor is pleased to let you know that this newer law, Act 135 that is in use throughout our state. As a result, formerly abandoned and/or blighted properties have new owners and are back on local tax rolls. Specifically, House Bill 1363 to amend the Abandoned and Blighted Property Conservatorship Act of 2008 is based on close observation of the law at work in cities such as our own and communities throughout our Commonwealth. One of our key findings is that private sector developers, as well as nonprofits, like the concept of the law and understand its purpose, but they also express fear about the risks they are taking once they petition the court and obtain conservatorships. For example, we have had situations where a developer has filed a petition only to have the absentee owner decide he or she wants to sell the property after years of allowing it to sit unused and in disrepair and after causing the market values of neighborhood properties to plummet. House Bill 1363 provides guidelines for the court to determine whether such an owner is seriously trying to sell the property or attempting to thwart the proposed conservatorship. By encouraging payment of costs and developer fees, which I'll explain in a minute, by allowing the bundling of properties into one petition in limited and specific circumstances, and by shortening the time frame for court to hold the initial hearing, Representative Taylor's bill encourages developers, nonprofit entities, and real estate professionals to initiate conservatorships on properties that meet the strict requirements set forth in the Act. So when we talk about what the developer's fee is, we have amended in House Bill 1363 those terms, actually with input with many of the people in this room. The developer's fee is defined as a fee equal to the greatest of an amount equal to $2,500 adjusted upward by 2% each year, a 20% markup of costs and expenses of carrying out the approved conservative's plan, or, and again this is the greater of, 20% of the sale price of the property. This ensures that the person is going to ultimately carry the burden, or is proposing to carry this financial burden, will have some sort of reward and stake in the property that they're putting so much time into and making a commitment to the neighborhood and to the city to. One of the things we also wanted to do was expand the geographic proximity in which the conservator would have to have done work. Currently under the Act, a proposed conservator would have to have done a project within 1 mile of the place where they are petitioning. Now we're proposing that it gets moved to 5 miles. Also, we amended the definition of party in interest with regard to a resident or business from 500 feet of a property in question to 2,000 feet of a property in question. More importantly, what we wanted to do is get these cases moving. And right now, the Act allows for 120 days from the date of filing that there would be a hearing. Our bill, or amendment, I should say, moves that up to 60 days. These owners, most often than not, and we really tried to stress this, I know you all know this, these are abandoned vacant homes. We're not looking to kick out Aunt Matilda or Grandma who can't pay the mortgage or her taxes. City Council's already put some plans in place to help those people. These are people who have left it to decay, and has really caused an eyesore to the community. We look no further. We had one next to our district office in Bridesburg, big, beautiful property. The owner died. Her daughter was the executrix, just ignored us as we wrote to help them. We'll help you get rid of this. I got to know a homeless person by first name who used to sleep in the backyard. It's laughable if it wasn't so sad. It was over $10,000 tax delinquent. We worked with the local CDC and Sholey Turco, filed on that property. This was a property where the owner, or the executrix, sold it. However, we made sure through court intervention that the property was fixed as we would have proposed to have done it. We're proud to say that the house was renovated and sold to a local family for $260,000. And it is gorgeous. And one of the things that we're really looking, I guess, for council to look at, and I know you've heard this already, so I know I'm preaching to the choir. We have met with several of different departmental agencies, revenue, et cetera, on how to make this huge backlog of properties that the city has, over 40,000, a way to move them. And part of our biggest problem is there are right properties everywhere in the city, as you all know, for Act 135. Many of them have more taxes and liens on them than the worth of the property. We can't do anything with them. Our hope is if we can find a cohesive plan through discussions with you all on how to reduce those liens and taxes so that we can, or other interested groups can file, it's really a win-win, because right now the city's getting nothing from those properties that it's holding except paying to try to maintain them. Now all of a sudden the city gets something in the way of liens, bulk payment. A family gets a new house. And I don't care where you go, someone can use that. There is a developer, a contractor, who now gets to go to work and get paid for it as a result of that. And the city gets a continuing revenue stream of utilities and taxes because someone's living there and utilizing it. And I think that's really one of the ways I think we can really work to start using Act 135. And I know Mr. Abernathy will talk about the model that the PRPA is using, and I think it's a good one. Ultimately, I think with all of those things, we can really start to see some productive change. Just by way of clarification for the record, House Bill 1363, has been stated earlier, is sitting in Senate Appropriations after passing the House unanimously. We've spoken to Senator Pileggi, and we expect it to be passed and ultimately signed into law by the end of this session in June, hopefully sooner than June than later. So we expect to really be able to go to work in the fall, and I think that will encourage a much bigger umbrella for use. So I thank you all for your time and look forward to working with all of you.
Swanson?
Good afternoon, Councilwoman Tasco and members of the committee. My name is Rebecca Swanson. I'm the Policy and Communications Director for the Department of Licenses and Inspections. I'm pleased to have the opportunity to testify before you on the important issue of conservatorship and the impact it will have and currently has on blighted vacant properties throughout the city. I'm the Director of L&I's Vacant Property Strategy, so I see firsthand every day the negative impact blighted vacant properties have in our neighborhoods and the positive change that can be brought about by returning these properties to productive use. The Vacant Property Strategy is one of our most successful initiatives. We've cited more than 13,000 vacant properties for property maintenance violations, including violations of Council's extremely effective doors and windows ordinance. We have a dedicated court time called Blight Court. We work with the law department to find owners of these blighted properties, ensure that they repair or sell the properties or face fines. We have about a 50% compliance rate overall. However, not all property owners comply with their citations or show up in court. Many of the city's blighted vacant properties are owned by individuals who are deceased, speculators who purchased at sheriff's sale and then abandoned the property, or by blight lords who purchase dozens or hundreds of properties at a time and then let them rot while they hid behind shell corporations. These are our trickiest cases because we do not have a viable owner that we can cite and take to court. Our enforcement literally cannot continue because there is no one who will be able to take responsibility for the property. Instead, the buildings will continue to deteriorate, and that will often force L&I to use taxpayer money to abate the property in order to protect public safety. It is for nuisance properties like these where our enforcement has reached a dead end that creative solutions are needed. It is in the city's best interest to get these properties into the hands of responsible owners and return them to productive use as quickly as possible. Through our work on the vacancy issue and our work with everyone in this room today, we have found that conservatorship is one of the most impactful ways to do this. Other solutions such as sheriff's sale are available, but we believe that conservatorship is the most effective and efficient tool. We believe that the city can support conservatorship in a way and make it be part of the city's overall blight reduction and neighborhood development strategy. Just quickly about L&I's role and how we've been involved with conservatorship. Our work has been focused two ways: on outreach and education for groups that can use conservatorship, and also on litigation support for conservatorship petitioners. In conjunction with many of the panel members today, as well as with the city's Commerce Department, we've provided training and education to community development corporations and community groups. We've also used our extensive collection of data on vacant properties to assist potential conservators. We use this data in a number of ways. We can help them identify properties in their neighborhoods that are vacant and have the property maintenance violations that would make them a good candidate. We can provide them with ownership information to let them know if we believe the owner is dead or a defunct corporation, which would make that a more attractive candidate for conservatorship than a property with an active owner. And we can also give them our complete violation history so they can get a picture of what's going on with the property, whether it has a doors and windows violation or might have some more serious violations that would make it a more expensive proposition to rehabilitate. So we can kind of give them a picture of what they'd be getting into before they can file the petition. Once a group chooses to file a petition, we kind of serve as a partner going forward through the litigation process. We provide our notices of violation from our property maintenance citations so they can use them as evidence in the filing. We also can provide updates on the property's current condition, and we send an inspector to testify at the hearings as to the history of blight at the property. In this role, we've participated in a number of successful petitions, and we've seen some of our most problem properties, properties that we've taken to court and gotten judgments against the owner but have seen no resolution and no compliance. We've seen them get returned to productive use in responsible hands of owners. We just see conservatorships as a way that the city can partner with community groups to effect real change in neighborhoods. And the practical effect has been that neighborhoods that have been ravaged by blight and are really struggling with vacant properties are starting to see stabilization and revitalization. So thank you for the opportunity to provide testimony, and happy to answer any questions.
Thank you very much. Did I understand that you were saying that owners of these blighted properties pay their taxes, but they just sit on the vacant property and don't do anything about it?
For some of them, yes. I mean, there's some where the owners are long gone and they haven't paid taxes either, but there are others who someone is paying taxes, but they've continued to just neglect the property for years and years.
Okay. And so once you go after them, once someone files a conservatorship, then they show up and then they take action?
They may show up in court for the conservatorship hearing, but they haven't shown up in response to L&I citations. We've taken someone to court, to our blight court, gotten a large judgment against them. They never showed up they were served, they never came to court, they never responded to any of our violations. But then as soon as the conservatorship petition was filed, they magically appeared and showed up in court there. So once we take someone to court and get a judgment, and they still refuse to comply, there's literally nothing else we can do except wait for it to deteriorate to the point where we have to demolish it. So this conservatorship can kind of fill that gap after the property owner has just ignored us, or might not be around to even get our citation.
Thank you. Any other questions? Brian? Yes.
Good afternoon, Councilwoman Tasco and members of the committee. I am Brian Abernathy, Executive Director of the Philadelphia Redevelopment Authority. And I'm here to testify in Resolution number 140025 on the Abandoned and Blighted Property Conservatorship Act. Before I start, I want to thank Representative Taylor and Ross and their staffs for their leadership and innovation on this issue. They have given us some sharp tools to deal with abandoned properties, conservatorship, land bank, estate transfers. I look forward to continuing to work with Representative Ross, and I'm sorry to see Representative Ross leave the Assembly. We're going to miss his leadership. A number of witnesses have testified on how conservatorship works on proposed amendments that are pending in Harrisburg, and rather than reiterate any of those comments, I wanted to touch on how the Redevelopment Authority, what our interest is in conservatorship and what our hopes are for the coming fiscal year. Conservatorship can be a fairly complex process for the average community organization. The legal requirements, the amount of information needed for the petition, the capital required to renovate one of these properties, the ability to sell the property, and the detailed understanding of a neighborhood's market to ensure that the conservator doesn't lose money are all important aspects. Fortunately, the PRA is ideally situated to handle this type of work. As some of you know, the PRA has filed its first conservatorship petition a few weeks ago for a long-term blighted property in Councilman O'Neill's district. This petition is a
Could you speak in the mic?
I'm sorry.
Speak a little slower.
Yes, ma'am. I sometimes rush through things.
I can't hear that fast.
As some of you know, the PRA filed its first conservatorship petition a few weeks ago for a long-term blighted property in Councilman O'Neill's district. This petition is a test for us to better understand the process, as well as to better understand how our tradesmen work through a renovation. We hope it's the first of many, but recognize that the current conservatorship law, which does not allow for a developer's fee, makes conservatorship at any scale difficult. Should the law change and should the PRA identify funding, I hope this program would expand rapidly to stabilize neighborhoods in transition. At the same time, the PRA wants to support community organizations that want to engage in this type of work by themselves. This support may be services that are provided for a fee, or if we can identify appropriate funding, this may be a loan product that provides upfront cash that the project needs. Whatever the case, the need for a broader use of conservatorship is undeniable and city support needed. Since I've been at the PRA, I've been approached by council members, CDCs, community organizations about how they might be able to deal with individual vacant structures. This is one tool that may provide some relief. As I close, I want to reiterate that this is one tool, just like the land bank is one tool. This isn't a silver bullet for all vacant parcels, and conservatorship isn't appropriate for all vacant parcels. But it's an important tool in neighborhoods that are either transitioning up or transitioning down to stabilize communities as we move forward. Thank you for the opportunity to testify today, and I'm happy to answer any questions.
Thank you very much for taking time to come over.
Of course.
And glad you're working with us.
It's nice to be back.
Councilwoman Sanchez.
Yeah, Rebecca, if you could have and forward to the chair the cost for the services. It was mentioned earlier that L&I does charge for this testimony and stuff. Do you have a scale for that, what the average cost is?
It's just a subpoena fee, and then I can forward that along.
What is that?
I don't know it off the top of my head. And then the inspector just takes a few hours out of their day to come in and into court and testify.
So one of the issues that was brought up, if those fees could be paid after a settlement versus upfront. So if you could respond to that, you can send that to the chair because it was an issue that was brought up. For the record, I think it's important that we have that.
Absolutely.
Okay. And then I had for Brian a couple of questions. Because I think it's important. I'm glad that the PRA is looking at this potential toolbox to do this work. Are you using kind of your NSP protocols? How do you foresee, when we talked a little bit around this, you foresee us being able to use some of the NSP stuff and be able to apply it?
We're currently looking at various funding sources, whether that's NSP, I think HTF is a Housing Trust Fund is an interesting option.
I'm looking at policy first, and then we can talk about
Sure,
funding.
so policy first, we actually are targeting specific neighborhoods, or we would be targeting specific neighborhoods, and again, those would be neighborhoods that would generally be on the cusp. Taking a look, using NSP as the model of how we chose those, I would probably be a little bit more expansive as we look at the data than NSP was, because they were limited by federal funds and census tracts. But I think the idea of NSP, the idea of block stabilization, is certainly what I want to continue to push forward.
And you talked about helping CDCs and others. Do you foresee yourself being able to create a process whereby it would help us kind of set the administration in a place where they would feel okay around dealing with some of these liens? Do you foresee yourself playing that role in helping us determine what would be kind of eligible if we applied the current policies?
Sure. I'd like to be, and I have engaged the administration on some of those concerns as we look at conservatorship, and I think we can certainly be a bridge to the administration to really plow through some of the conversations.
To do some of that. And again, and then let's talk a little bit about funding, because I don't know if you've had any conversations about potentially using the Housing Trust Fund to fund some of this.
We have not actually specifically engaged OH City on Housing Trust Fund. We have been looking at potential funding sources for quite some time, and I actually, to be very forthright, thought we had a funding source that would work. Unfortunately, it doesn't look like that funding source is going to be viable after all. And so we're beginning the process to re-explore what other sources, whether that's, again, neighborhood stabilization, Housing Trust Fund. In certain cases, the remaining NTI funds might be available. But again, that's a conversation with bond counsel.
For recycled NTI money?
Certainly using the sales and liens money would be easier.
Because it's clean?
Because it's sort of clean.
You can use that term. Let's just say it's unencumbered.
Right. I think that anything with NTI, and I will be speaking with each of you individually, but the ability to acquire new parcels is going to be very difficult with the new eminent domain code. And so really thinking through how we use those funds going forward is going to be key, and this is one potential use.
Okay. Outside of those, have we looked at potentially getting either a foundation or maybe engaging some of the banks who have been unwilling up to now in a more secured way? If, let's say, if they see PRA involved, do you think we can move them?
So I think one of the things that Mr. Vanderslice said that I had not been thinking of was a secured loan product. It's not. We've looked at that for other mechanisms or for other projects, but not for conservatorship specifically. It's something I would be interested in exploring. We've also spoken to some financial institutions about how could we provide the cash for their in order for them to lower their interest rates, a partnership similar to PIDC's small business loan program. That would have to be done through an RFP process, and again, I would need to identify the funds in order to make that project to work through. But yes, I think all of those are strong options. I've actually, as far as support to not-for-profits and CDCs, we're hoping to have a business plan and more information in place for the beginning of this next fiscal year. So it is something it's very high on my priority list to move forward.
So it'll be part of the comp plan discussion?
It may not be part of the con plan because it may not be federal funding that funds it.
Okay.
And so that would be why, but that's part of the conversation. And again, I think this goes back to the idea of the PRA repositioning itself. It's definitely a state of transition, and finding our role going forward is key.
Okay. Well, I look forward to seeing that, particularly with the Housing Trust Fund opportunity that may exist there, and the NTI, wherever I could be helpful in kind of moving that along. I'd like to move it along. I think you're right. If you can come up with a system, and clearly there's some lawyers who've already developed a system that we could help the CDCs in smaller groups, we should definitely strengthen that toolbox. So I look forward to working with you on that.
Absolutely.
Thank you.
Okay, thank you. And questions? Anybody else? Thank you very much. You've come here to educate us so much and give us information. And surely the other council members listen on their boxes in the office and also watch on television so that they're not here. But I want to thank my council members for coming. Is there anyone else here to testify on this bill? Oh, Laura Conn. I'm sorry. Come on up.
Good afternoon. Thank you, Chairwoman Tesco, for the opportunity to testify, and to all the committee for addressing these issues. Oh, sure, and more slowly, I imagine.
Speak
as well.
slowly. Okay.
Thank you. And happy Mardi Gras to all of you.
Thank you.
I can't resist. I am offering creative conservatorship concepts today.
Okay.
So I hope to live up to that. My name is Laura Conn. I am testifying in my capacity as the staff attorney with the Public Interest Law Center of Philadelphia. Through our Garden Justice Legal Initiative, I provide pro bono legal and policy support to Philadelphia's gardens and farms. I'm also the chair of the Vacant Land Subcommittee of the Mayor's Food Policy Advisory Council. The city for years has tacitly accepted gardening and farming as a core strategy in revitalizing and repurposing vacant parcels. Yet community groups have no clear path to legal access, much less permanence, even when garden spaces have become undeniably sewn into the fabric of a community. Our biggest set of land transfer quagmires are privately owned parcels, tax delinquent and abandoned. The land bank will be a transformative tool, but we need all the tools we can use. I have two quick stories for you, the first in which conservatorship would have made the difference, and the second one in which we hope it will. The first was my first client at the Law Center, a Grace Ferry institution, Central Club for Boys and Girls. Incorporated in 1947, the group began cleaning, greening, gardening, and stewarding vacant lots back in the 1930s. These lots were the sites of demolished homes, some of which last changed hands as long ago as 1911. There have been no owners in evidence for many decades. The organization revitalized these spaces, teaching youth gardening and other skills for over 70 years. In 2005, certain parcels came up for sheriff sale, purchased by speculators who have taken no action since that time. Eager to keep community spaces in the community, the organization obtained title to some of the remaining parcels through a lengthy quiet title action. However, when it gained title, Central Club was saddled with someone else's tax burden, putting it at risk of losing the properties, which is when the Law Center became involved. More recently, about a year and a half ago, I was contacted by a community development corporation, New Kensington CDC, about two parcels on Ann Street. A church group had begun gardening on them primarily to combat drug activity in the area. The church and the families involved wanted an opportunity to legalize and make permanent that solution. The problem, which is a familiar story, is that the two parcels are owned by an LLC that is unreachable and has no obvious intent to take responsibility, with $20,000 worth of tax and municipal liens, particularly demolition liens, between the two lots, and no market for development in the area. There's no timely or affordable mechanism to put these parcels in the hands of the community groups. Sheriff sales are not always the best option when the debt is significant, proportional to the market value. Further, sheriff sale pits community-based groups against speculators who purchase land only to leave it abandoned and neglected once again. Conservatorship actions combat these scenarios because they require the implementation of a court-monitored plan. That plan and the court's involvement serve as an accountability mechanism for any type of petitioner, community group, for-profit developer, or individual. Conservatorships would have made all the difference for Central Club to take action and continue their important work. On Ann Street, with the support of the CDC and the Department of Licensing and Inspection's vacant property strategy, the church group is poised to pursue a conservatorship action when the time is right. Yet my clients do face barriers in utilizing this tool. First, we're waiting to see the act amended to include vacant lots on which a building has been demolished. That amendment will open up another set of opportunities to put conservatorship to work in Philadelphia. Second, as the best practices manual created by Regional Housing Legal Services makes clear, there's more guidance needed about the process for public and private sales of these properties at the end of the conservatorship, particularly for conservators or petitioners who actually want to purchase at the end, who want to be the end user. Third, we need a mechanism to clear the debt where appropriate. As everyone has said over and over again, the municipal liens are the barrier. Even a garden or green space takes capital investment, for example, to take proper precautions to remediate lead dust or other environmental contaminants. We should provide incentives for potential conservators not just to take action, but to be fully resourced when they do. I would also like to echo the testimony of Beth McConnell from PACDC that pro bono legal resources are also an issue. Finally, as a public health issue, Philadelphia's brownfields are some of the abandoned spaces most in need of attention, resources, and a plan. Conservatorship could provide the structure to remediate and repurpose brownfields, but organizations and developers will appropriately shy away from these spaces without support. We need a policy and programmatic framework in which to support petitioners who want to take that step. I appreciate the efforts of City Council to take leadership on these issues, and thanks for the opportunity to speak.
Thank you very much. Any questions or comments, Councilman?
About the vacant lot amendment, is that part of what we're talking to? Okay.
That's what we're waiting on. Yes, thank you.
Okay, so we will certainly be working with, the various organizations to see, and we'll wait for Representative Taylor's amendment, and then we'll see what we can do to move to incorporate and try and incorporate some of the suggestions made here today, and certainly, improve this program on the local level, because it seems to be effective, but it still costs dollars. So, thank you. Anyone else here to testify on this this resolution? Okay, there being no further witnesses, this meeting will be adjourned to the call of the chair, which leaves it open that we do not have to really advertise again. We can just call you. Thank you so much for coming. Thank you so much for coming. Thank you so much for coming. Thank you so much for coming.